2013, so the different types of companies. The world of commerce, a company is more than just a place of work or a collection of assets. It is a legal person created by law. But who governs these legal persons is in India. The answer lies in the Companies Act 2013. This act replaced the aging 1956 legislation and brought Indian corporate law into the 21st century. It introduced modern concepts like one person companies, CSR mandates, and digital compliance. Today, we will unpack the meaning of a company, its defining features, and the various structures it can take under this comprehensive act. At its simplest, a company is an association of persons formed for a common objective. Under Section 2, subsection 20 of the Act, a company is a company incorporated under this Act or any previous company laws. The most critical concept is the separate legal entity, that the corporate veil. Once a company is registered, it becomes a distinct entity from its owners, that is, the shareholders. It can own property, sue, and be sued in its own name. The most critical concept here is the separate legal entity. Okay, that is what I discussed now. That is, uh, when once it is registered under the Companies Act, it becomes a distinct entity from its owners. Okay, that it means that it will own its own property, it can sue on its own on others, and also can be sued in its own name. Perpetual succession. It means the company never dies. Even if its members change, retire, or passes away, it has a life of its own, separate from the humans who manage it. Let me discuss about the core features of the company. What makes a company a company? Okay, it is its limited liability. It is the biggest draw for investors. If a company fails, the liability of its shareholders is limited to the unpaid amount on their shares. Their personal property remains safe. That is why it is called as limited liability. So it is limited to the on amount of shares that they hold in the company. Artificial person. A company is an artificial person created by law. It cannot walk or talk, but it acts through a common seal or authorized directors. Transferability of shares. In public companies, shares are freely transferable. This allows investors to buy and sell the shares without disrupting the company's operations. Separation of ownership and the management. In most large companies, the people who own the company are not the ones who run it. This allows for professional specialized management. Now, let us dive into the different types of companies. The Companies Act 2013 is flexible in how it categorizes businesses. The companies are categorized into private company, public company, one person company, foreign company, etc. So let us discuss about each type of company in detail. So what does private company means? A private company is defined by restricted share transfers, a maximum of 200 members to be available in private company, and a prohibition on inviting the public to subscribe for shares. That is, it cannot raise funds by inviting the public to subscribe the shares. It is the preferred choice for family run or closely held businesses. And the maximum numbers under private company is only 200. Okay, the members would be private members, like it would be family members or friends or relatives. Public company, a company that isn't private is called as a public company. It can invite the public to buy the shares, has a minimum of 7 members, and has fewer restrictions on share transfer. Okay, minimum of 7 members is mandatory if it is a public company, and public company can raise funds by issuing shares to the public. And once the shares are issued to the public also will become the shareholders or owners of the company. One person company. This was a game changer that was introduced in 2013 Act. It allows a single individual to form a company with limited liability, bridging the gap between a sole proprietorship and a private limited company. So this was one of the inclusions under the Companies Act 2013. There are also different other types of companies like limited liability partnership, where what is limited liability partnership? It is not exactly a company under the Companies Act 2013, but it is a distinct hybrid structure that is governed by the Limited Liability Act 2008. What does it mean? It combines the flexibility of a partnership with the limited liability protection of a company. The advantages of the limited liability company is a partnership is it is easier and cheaper to manage than a private limited company because it has fewer regulatory compliances and audit requirements. Unlike a traditional partnership where personal assets can be attached to pay business debts, partners in a limited liability partnership are only liable to the extent of this agreed contribution. And there are other specialized classifications like holding and subsidiary companies, where a holding company is one which controls the composition of the board of directors of another company or holds more than half of its total share capital. Government companies, the company in which not less than 51% of the paid up share capital is held by the central government, state government, or partly by both, they all fall under government companies. A foreign company is a company incorporated outside India that has a place of business in India or conducts business activities in India either physically or electronically. There is one more type of company that is called as dormant company, where it is formed for a future project or holding an asset or intellectual property and has no significant accounting transactions. It is just a way to keep the company alive without active operations. The type of so private company, one person company, public company, they are all are governed by the Companies Act 2013, and the complexity of management of these companies is, if it is a one person company, it is low and the liability is limited to that person. If it is a private limited company, okay, the liability here also limited to the assets or the shares that they hold in that company, and the management the complexity is moderate. If it is a public limited company, it is also the liability is limited, but the management complexity is very, very high. Looking at other types of companies, that is limited liability partnerships and partnerships, okay, which are governed by Limited Liability Act 2008 and Indian Partnership Act 1932. The liability is limited under limited liability partnership, and if it is a partnership company, the liability is unlimited, but the management complexity is low under partnership company, and for limited liability partnership, it is low to medium. So it's important that the Companies Act 2013 is far more than just a regulatory rule book. It is the framework that balances the interest of entrepreneurs, investors, and society at large. By moving from a regime of strict control to one of self regulation, transparency, and digital compliance, this act has transformed the Indian corporate landscape, whether it is through the flexibility of a one person company for individual innovators, the professional structure of a private limited company, or the massive scale of a public limited company. The Act provides the right vehicle for every stage of business growth. Ultimately, the corporate form, with its features of separate legal entity, limited liability, and perpetual succession, is what allows businesses to dream big, take risks, and contribute to the national economy without compromising the personal security of the individuals behind them. Understanding the Companies Act is the essential first step for anyone looking to navigate, lead, or build within the Indian business system. Thank you for your attention, and I hope this overview provides a solid foundation for your continued learning. Thank you very much.